world over, there is a higher threshold when you talk about public office holders. Those individuals, by virtue of their office, must be able to endure more criticism. They take oath, they are accountable to the citizens.
For me, what's really concerning is from an application point of view, and because you mentioned the notices that were sent to journalists, right? And last year, the JIT and everything. So, what they've done is expanded the definitions of who can be a complainant, right? Again, like anybody who thinks an offense has been committed under the act can go and file a complaint. And then what they've done is change the definition of person. And why this matters is because cases were quashed and thrown out of court on the basis that they don't meet the criteria that has been laid down.
Members of content creators saying that they are being censored and that they are not being able to sort of speak freely. And there was a need to genuinely reform the Prevention of Electronic Crimes Act, but not in the way that you have done. You have made it, as I said, even more oppressive. You have scrapped the entire structure. You have imposed a new superstructure. There's a new investigative agency. There's a new social media complaint cell, and there's a new authority, and there's a new tribunal. So I don't see what they're trying to do here other than try to censor people who are speaking online. That seems to be the aim of this law.
Hello and welcome to this episode, which is a collaboration between Case in Point and DigiPod. And today we are discussing the Prevention of Electronic Crimes Amendments 2025. I'm Farieha Aziz. Rida Hosain, the host of Case in Point, is here as well. Rida, let's talk about, Peca, the amendments. And I know that we want it to be in a way that people understand that this is not just, there's a lot of conversation that this is about journalists and it's going to affect journalists, but this is going to affect every Pakistani who essentially uses a mobile phone and the internet and social media, right? And so what we're going to do is structure so it's easier for everybody to understand, because there are two schemes, the criminal side of the law and the offenses and the regulatory side. And so we're going to break it all down for our audience. Rida, do you want to start?
There are many aspects, Farieha, of the Prevention of Electronic Crime amendments which have been introduced, which, in my view, on the face of it, are unconstitutional. And the amendments have made an already draconian law, an already oppressive law, even more oppressive. We've seen since its enactment in 2016 how the Prevention of Electronic Crimes Act has been misused. And if there was a genuine, real attempt at reform, in my view, it would not have been done in the way that it's been done right now. And there's very little space for dissent in Pakistan. And this law and these amendments, in my view, are just a reflection of the fact that the space for dissent, the space for criticism is shrinking. And we've seen, even if we look at this past year, we've seen terms such as digital terrorism used. I still don't know what that means. And the state is very insecure. The state is very sensitive to any kind of criticism. And this law is just, in my view, as I said, these amendments are just a reflection of that. If we talk about the offenses that have been created through the amendments, there has been a category which has been created, which is unlawful or offensive content. And one of the categories of unlawful or offensive content is information that is known to be fake or false. So fake or false information has been included within the ambit of unlawful content. Now, what does information that is fake or false mean? It's a very vague, it's a very broad term, and laws must be drafted with a degree of clarity. Because if there is no clarity in the law, it is open to misuse. And we as citizens should not have to second guess what the law means. We should not have to speculate what the law means. And when you use broad terms such as fake and false information, we will have to speculate what that means. And it also gives more power to the law enforcement agencies to misuse that law if it is crafted in vague terms. And even if we talk about terms such as fake news, it's the kind of terms which have been deployed again by the now President of the United States, Donald Trump, to attack members of the media, to attack members of the press that used to hold him account during his presidency. That would be his line of attack, that any kind of sort of question that would be put to him to hold him to account, he would respond and say, this is fake news. On just the content part, is that aspersions against members of the armed forces, the judiciary, members of parliament, or the provincial assembly. And aspersions has been defined to include false and harmful information which damages the reputation of a person. And when we talk about political debate, when we talk about, citizens holding the government to account, that is often very harsh criticism. Justice Athar Manila, when he was a judge of the Islamabad High Court, struck down a similar section of the law which related to harm to reputation.
And false information already existed in Section 20, right? And it was being applied and misapplied. That already existed too. And again, who and when are they going to determine what is fake or what is false? So to give an example of, for example, the ban on X, right? The government never admitted at the outset that it was through an official notification or they had anything to do with it. So if someone were to say, no, actually PTA shut the website down, would that be categorized as a false claim just because they deny it, and then ultimately later emerges that there's a notification and that it's actually a Ministry of Interior notification, but the varies of that has been challenged. So how does it even play out? And I mean, it's a Trumpian term. Fake news is a Trumpian term. I mean, disinformation, misinformation, but you don't criminalize it. And also in terms of criminal defamation, world over, there is either a non-enforcement policy or a decriminalization policy, but we are adding on layers and layers, right? So we've got what, and correct me, we've got 499-500 is the PPC, which has defamation. We've got Peca now. We have the Punjab defamation law, which has a separate structure. We have the civil defamation laws. So I don't understand when the government says that there's no legal scheme and there's so much fake news, but there's already all these instruments and they were using it, right? What I do want to know is how does this stand against the test of Article 19? This entire category that they've created where you can't say something about members of armed forces and members of parliament. And then also that if there's something that's expunged during live proceedings, then you can't, like, it can't be discussed, or you can't basically put it up. But the thing is that somebody will say something first, it will be a part of live proceedings, so you will comment on it, then it'll be expunged. So how do you do this in reverse order, like practically?
So I'm glad you brought up Article 19 because Article 19 is a justification which is often given in courts and even by members of the government on the press. They say that, Article 19 of our Constitution, it's not an absolute right, the right to free speech and expression, and it's qualified by reasonable restrictions. And then there are a host of reasonable restrictions which the Constitution identifies. But our courts have interpreted Article 19 in numerous judgments, and they've said that the reasonable restrictions which Article 19 of the Constitution identifies have to be interpreted very narrowly. And they cannot be interpreted in a way that you use those reasonable restrictions to suppress free speech. And that is what we see happening. The reasonable restrictions are used as a manner to suppress free speech. And even if we go back to what Justice Athar Manila decided when he was a judge of the Islamabad High Court, he also in his order relied on Article 19. And he said that Article 19 guarantees free speech, free expression, which go to the heart of any democratic society and which are necessary for the prosperity and progress of any democratic society. And to suppress free speech in the manner that is trying to do, that is unconstitutional. So our courts have said that this has to be interpreted in a very narrow manner. And even if we talk about this amendment, when we talk about aspersions against members of parliament, members of the armed forces, in my view, there needs to be a shift in the conversation because, again, world over, there is a higher threshold when you talk about public office holders. Those individuals, by virtue of their office, must be able to endure more criticism. They take oath, they are accountable to the citizens, at least judges and, even members of parliament. So they are accountable to the citizens, and citizens must be able to speak in free terms. So all world over now, they are saying that there has to be a higher standard when we talk about public office holders. And over here, we have a state that is so insecure that members of parliament and even the judiciary, they are more insecure to criticism and they can't tolerate any kind of criticism. We saw even earlier last year where a whole host of FIA notices were sent after, because they were saying that the judiciary was being maligned. So there has to be a shift in the conversation that when we talk about public officials, when we talk about public office holders, there has to be a higher standard.
Anybody can essentially, they will be categorized as a person making this complaint, which also means that if you have reported about a corporate body. So, for instance, I remember that there was this case in Karachi where a climate environmental organization had reported on this oil spill near Charna Island, and they held responsible a petroleum company, and they named them in their press release. And they filed a complaint with the FIA under Section 20. There was a raid at the offices, search and seizure. Now, the law didn't cover it. As a corporate entity, they didn't qualify as a natural person, but it still happened. And so that chilling effect where, the basis of a press release for an environmental issue. So we can see the broad implications now that it's legalized. They will say, yeah, we have standing in court. We can go after you for anything and everything. I mean, this is just going to chill reporting and expression in every way, where every person is talking about a public interest issue that relates to them, but now they can face criminal action because anybody can file a complaint against you, and depending on the clout that they have.
And even, when we talk about the definition of person, as you said, even before this amendment came, we saw FIRs being filed on harm to reputation of institutions. So we would have criminal complaints on the basis that X person has damaged the reputation of the judiciary or has damaged the reputation of another state institution. And this is also when we talk about what the trend is world over, because it's important to see what the best practices are internationally as well. Laws are crafted to protect the reputation of individuals, not the reputation of state institutions. You cannot make laws to protect the reputation of state institutions. And it was something that was happening even before this amendment. And now the fear is that with this amendment, they'll have more of a cover sort of to make these kind of complaints. And again, when we talk about the scheme, if we can go to the regulatory aspect of it now, that the problem is that the federal government has inserted itself in the appointment process of most or not all of these new authorities which have been created. So if we talk about the Social Media Protection and Regulatory Authority, which will regulate unlawful content online and which has the authority to remove and block content which they perceive as unlawful, majority of the members will be appointed by the federal government. So you have majority federal government appointees deciding what is lawful and what is not lawful. And not only does the federal government have the authority to appoint members to this authority, but the federal government also has the authority to remove members from this authority. And they can be removed on grounds such as mental or physical disability, misconduct, and inefficiency. Now, what does inefficiency mean? Again, it's such a broad term. You're removing a member from an authority on grounds of inefficiency. So again, this may be misused by the government, that if they perceive a member not to be following the government narrative, they could remove him and say, well, actually, you're inefficient, so we're removing you. And an authority which has majority federal government appointees will be an authority that will be perceived to be serving the federal government. And where content is directed at the government, federal government appointees cannot be deciding whether that content is lawful or not lawful. And even if we talk, yes, there's a clear conflict of interest. And even if we talk about the tribunals, those have exclusive federal government appointees. So the social media protection tribunals, all members are appointed by the federal government.
And so now the tribunal's final order can only be taken to the Supreme Court. Now, not everybody has access to the Supreme Court. And this is very deliberate. On this, I think there's a need to make a connection also for people to understand where all of this is coming from, right? And to understand that now the structure has changed. So there's no longer the FIA for prosecution. A new agency has been created under these amendments. Again, the federal government is going to notify and do the appointments. And then you have the Social Media Regulatory Authority. And this is similar to what PTI was trying to set up as PMRA, right? But here you have Chairman PTA, Chairman PEMRA, Secretary Ministry of Interior as ex officio members. And then even in the decision-making quorum, you can see that, they will prevail, obviously, and the appointments are going to be made by them. Not only can this authority say what is prohibited content under the categories that have been now further listed, but require companies or, social media platforms, the way they've defined it, can even go on to somebody who manages a platform, which could be an admin of a group. So you can then require them to not only send notices, require them to register. All of that has been left to rulemaking. How are you supposed to register? Who's supposed to register? At what cost? We don't know because they will decide later in rulemaking.
So in my view, there's not even any pretense anymore that this authority that they've created will be taking decisions independently when they've said that what we, the federal government, will say will be binding on this authority as far as matters of policy are concerned. So that pretense that, this is an independent system, that immediately goes away. And you talked about the FIA and, how we had the FIA before this. And again, it's important for us to raise questions that when you had an investigative agency, however flawed it was, whatever the issues it had were, improve that agency. Why have you scrapped that entire system and imposed this new system? Similarly, Peca, there were a lot of issues with the law, and there was a lot of voice from civil society, from members of content creators saying that they are being censored and that they are not being able to sort of speak freely. And there was a need to genuinely reform the Prevention of Electronic Crimes Act, but not in the way that you have done. You have made it, as I said, even more oppressive. You have scrapped the entire structure. You have imposed a new superstructure. There's a new investigative agency. There's a new social media complaint cell, and there's a new authority, and there's a new tribunal. So I don't see what they're trying to do here other than try to censor people who are speaking online. That seems to be the aim of this law. And you can't attribute malice to the legislature, which is a principle which is settled in our jurisprudence as well. But when you see laws like this, you do question what the intent of these laws are. And when you talked about the impact on content creators, on people that are creating content digitally, one of the most striking sections, which you also mentioned, that any person can make a complaint under this law that, I'm aggrieved by this content, even though they may not necessarily be aggrieved. So any person can make a complaint against content, and it's not just restricted to aggrieved persons, which may mean now that those who are creating content online, they may be subject to more complaints by people who are third parties who it has nothing to do with, making complaints about their content. So the way that this law is crafted, it is very dangerous, and it is open to grave misuse by the executive and also by what we call, proxy petitioners or proxy parties making complaints against content which is online.
Then there's that. And the other thing I want to quickly ask you before we wind up is from a Article 10A perspective, because what I saw in this is that the NCCI, which has now replaced the FIA, it can now establish its own capacity for forensic analysis. And what this section says is that any report generated by the NCCI, which is the investigation and prosecution agency, shall not be inadmissible in evidence before court, right? So, they've taken your devices. They have an interest in prosecuting you. They want a conviction against you, let's say, or to put you to trial. And then at face value, anyway, a lot of forensic reports were taken. But here, is there no clear conflict of interest? And what about fair trial rights?
So, Priya, we talked about Article 19, about how it has reasonable restrictions. When we talk about 10A, it says that every person shall be entitled to a fair trial and due process. It is not qualified by any restrictions. It is an absolute right. There are no restrictions on this right. And again, our courts have interpreted it that you cannot restrict the right to a fair trial. There are no restrictions in the Constitution. It is absolute. So yes, I do think that there is an argument to be made that it does violate Article 10A rights because A, there should be some independent oversight over this entire process. And that's what this entire law is trying to avoid. That's what these sort of amendments are trying to avoid. They're trying to avoid an independent oversight process at every stage There is no independent oversight. When the government is doing things that is not independent, those decisions, as you say, the government has an interest in those decisions. So there has to be some independent oversight over the process, and it's not there even at the investigation stage where they've been given these sweeping powers. And it's not even there at the tribunal stage. And again, as you said, they've taken away the right to appeal to the High Court as well. And they've taken away an appellate right, which I also think is not consistent with 10A. And there's an argument that even that goes against the right to a fair trial. You've taken away one layer of appeal, you've taken away one layer of an individual to fight something that has sort of been brought against them. And you said you only get one bite at the cherry, whereas otherwise you would have gotten two bites at the cherry. So you've taken away that right from them. And I think even that goes against the scheme. And there's an argument to be made that that goes against Article 10A.
So just to sum it all up, and we're sort of now also on the clock, anything that you want to add finally about this law structure?
About the law, I think we've covered it. What I do want to add is that I don't think that this law can be really looked at in isolation, because I think that it's a continuation of what has been happening for the last few months, or rather even for the last few years, if we can, take it back. And post the 26th Amendment, now you have a judiciary that the executive is trying to control. The executive, the government, they're trying to assert control over the judiciary. So previously, you would go to the courts for relief against laws like this, against amendments like these. But when post the 26th Amendment, even going to the courts for relief is something which people do not have faith in anymore, that they will get that kind of relief from the courts, because post the 26th Amendment, I do not think that the judiciary is independent, because the key principles of judicial independence have been violated by the 26th Amendment. And laws like this, they sort of, citizens will not feel protected, not by laws kind of like this, and also because they will not feel that they can approach the courts.
And that again, your right to remedy has been frustrated by the procedures and also what has been written in, and just the general overall sort of executive capture that we've seen creep in. But for the audience to know that, look, this applies to every citizen of Pakistan. It has been applied in this manner. This is not just about, the independence of the press and how it's going to impact them, but this is about you. You, as somebody who uses social media, will fall within the ambit. Anybody can initiate action against you anywhere in Pakistan for anything. And that's just why this law raises such concerns, because it is so vague. You do not know what will be considered fake or false. By the time that you get to a stage, if at all, to get into that before a court or a tribunal, the damage will have been done, whether through a coercive criminal process or regulatory action, which is going to impact you and your platform. There can be costs associated with all of this. And then this essentially is going to have a chilling effect, where people will start to self-censor and not post or not create those platforms, because they can't incur those kinds of liabilities, whether monetary or otherwise. This is all that we have today from Case in Point and DigiPod. We will have more discussions on this law. Thanks, Rida.
Thank you.